everybody. Thanks for tuning in. I'm going to give everybody a second to get on here. Hope everybody had a great day. I'm running a little late. Had court until almost 6 o'clock tonight. And then, hey, Dana, sorry, too many N's. Had court until almost 6 o'clock and then got home and wanted to print out and look at some stuff for you guys before we started answering questions. So since I'm running a little late, I will give everybody a little bit more time to sneak in here, and we'll figure out what's going on. I hope everybody had a great day. I was on the road, as is pretty typical for me today. Drove back out to Tulsa and back, and then had court out in Canadian County, which, if you haven't heard, is where I'm running for judge. And then I'm doing this tonight on my new iPad, but my husband was nice enough to go get and take care of for me since I have somehow lost the other one that I've had. So he spoiled me a little bit. I appreciate it. So hope everybody else had a great day. I went through the OMMA status update from yesterday, the materials that they printed out, to see what kind of information it could provide me. I tried to print out everybody's questions that everybody had submitted in advance so that we could answer those questions. Hey, Richard. So I've got all of that ready. If you have a question, by all means, please type it in and I will do my best to respond. I can't promise that I know everything, but if I don't know, I will do my best to get you an answer and get back to you, because this is certainly an area that is developing and I'm still learning about, along with a lot of other lawyers here in Oklahoma. I just happen to be one of them that have the lawsuit on file and are working in that background. P.S. Tara, I'm wearing your shirt. It says, "Good girls know the rules, bad girls know them better." It's my roller derby shirt that my friend Tara Cowles got me, and the back says "Tort you her" on it as a play on torturer, because, well, I have a bit of a reputation for torturing people sometimes, but it's all in good fun. I'm really a nice person. Shh. So anyway, we've been going 5 minutes or so. I'll give a few more minutes to see if anybody else shows up. Oh, there's my husband. Hi, Dwayne. Thank you. You're welcome. Like I said, if anybody has questions, by all means, please pop in and we'll see what we can do. Hi, Luke. Those who don't know, Luke helped sort of organize this. He was asking me a lot of questions yesterday on Messenger, and we were talking back and forth, and he asked if I could make a video to help address some of the questions that everybody had. So I've been trying to do that. If you haven't seen them, I have done quite a few videos with Jason May's Emo, and we've done some talking there, but I know he doesn't always leave everything up. So just in case you didn't see him, to give a couple of rules. One, I am a judicial candidate, and so those rules are very important to me as a individual who's running a race. It's a nonpartisan race. I can't tell you what party I'm a member of. I can't tell you my excuse me, particular views on pending legislation that hasn't been developed, and I can't tell you how I would rule on something. So don't ask me those questions, because I'm not going to answer them for you, and that's not me being rude. That's me trying to comply with the rules, which is very important to me. Also, everybody be nice, kind, and professional. I don't set out to try to attack anybody personally, so I would ask that if you ask questions here, that you try not to attack me or anybody else, because I think everybody is here to learn. And then I did appreciate everybody who submitted questions in advance, because it is sometimes hard to keep up on the screen with what folks are asking, and I know there is a little bit of a delay. If I am not speaking loud enough at any time, please let me know. I am a little sick, so I'm kind of rocking the sexy voice right now. And with that, I will get... What, are you short it as much as missing $507,000 plus on subject suit? That's a class action. Glenn, let me start there. We're not filing it as a class action because there's really not a benefit to filing the lawsuit as a class action right now. And that goes along with another question that was asked. This isn't a lawsuit that seeks monetary damages. Nobody's going to get paid at the end of it except maybe some lawyers if the court awards us attorney's fees and cost. It's what's called a declaratory judgment action. It's brought under the Administrative Procedures Act, which allows citizens to bring a lawsuit anytime they have actual damages or threatened damages. And since this is a brand new law and not everything has gone into place yet, we certainly have threatened damages. We do contend that there are some folks that have real damages, specifically those people who had started getting investors together, getting their businesses ready, whether they were going to run a dispensary or a processor or a grow. I've talked to a lot of people across the state who have lost money or lost investors because of the rules that have been put out there. So that's a big concern. So that actually does start to create the idea of actual damages and whether or not that's something that we shift into doing. And damages would be different for different categories of individuals. Hi, Dana. Hi, Bobby Lee. So the categories of damages would be differently based on whether you're a medical licensee or caregiver or out-of-state temporary licensee as opposed to a commercial licensee. And so those are things that would have to be looked at. Our lawsuit has, originally started with 8 people. Of those 8, 6 were patients, and a couple of them had also business interest, and then 2 of those had purely business interest. So we had a little bit of mixture. We did, in addition to filing the emergency injunction on Tuesday, thank you, Dexter, I appreciate that. In addition to filing the emergency injunction on Tuesday, we did file an amended petition. A petition is the legal document that starts a lawsuit, and it's called a petition in state court and a complaint in federal court. And since we're in state court, it's a petition. So we filed an amended petition setting out the issues for the injunction. And we did go ahead and add a couple of plaintiffs to that lawsuit. We added 2 veterans who had contacted me about veterans' interest. I have added 2 dispensaries as well as a grower and producer. And we have added a doctor because we think it's important for a doctor to be in there because doctors are being regulated in a way that we think is inappropriate as well. So I will talk about the lawsuit if people have some interest in that, along with You're Welcome, Dana. I think I sent that to you. If I didn't, let me know and I'll send it over to you. And if somebody can tell me how I can post that up for you guys to look at it, I'm happy to do that. I know there's been a lot of comments online about whether or not we are secretly trying to delay State Question 788. Are we behind the no movement, etc.? No. I know I did kind of come in out of nowhere. Nobody really knew who I was. Again, I am a judicial candidate, so I can't be out with activism, so there's always that issue. Secondly, part of my interest arose in this not from an activist standpoint, but from a legal standpoint. For me, it's a very interesting legal challenge. It's not very often in my career that one gets to come in and be on the ground floor of a new area of law. It's kind of like the civil rights movement was back in the 60s for me. This is an area that I'm particularly concerned about. One of my big passions is government overstepping and getting over involved in our lives, and that the government does what they're supposed to do and follows the law. So that's why I got involved with it. Additionally, I am a trial lawyer. That means my job is to tell your story in court, and that doesn't matter whether it's family court or divorce court, deprived court, an employment law case, personal injury, whatever. My job, first and foremost, is a storyteller. And one of those things that I have found well before all this happened was drugs and marijuana was a story that I told universally across all different kinds of cases where I had to stand up and talk to a judge and a jury about my clients and what was happening in their life. So when State Question 788 came up, it was an area of law that I knew I immediately had to get knowledgeable about because it was going to affect every area of my practice. Additionally, I had clients that were getting into this business and needed to know what they could and couldn't do. So that's how I started getting involved with it, and had individuals who asked me my opinion on the rules and said that they were overstepped and that they didn't follow the rulemaking process. So that's why we got involved with filing this lawsuit. I've said this before. If you'll look at the names of the individuals on the lawsuit, you'll see that at least 2 of the names have the same last name as me, Bussett. Those are my relatives. This is also important to me for family reasons, and those aren't the only family members that applies to. In particular, my nephew Nicholas is on there, and cannabis can help him and treat some conditions he has. My sister-in-law, Christy, is on there. She's Nicholas's mom. She's a caregiver for him. And so she has an interest in it. And as the lawsuit says, she has some minor children who might also benefit from medical cannabis in one form or another. So that's a personal issue. If you've called my office, excuse me, and you've talked to one of the ladies there, if you've talked to Crystal, well, you're talking to Christy. Not only is she a plaintiff, but she is my right hand. She keeps my world spinning, and she is an integral part of my law firm and this lawsuit. Hi, Frank. We haven't gotten anything substantive really yet, just given some background. Dawn Gregg, who's on here, she's one of my plaintiffs. She's one of the whistleblowers in my DHS case, which is also a case about government over-involvement, and you might have seen her on the news. She was terminated from DHS back in May after complaining about DHS not protecting kids. Same thing with Heidi Stingley, also a DHS whistleblower. There's an attorney on there who's a good friend of mine who benefits, as well as her father, and then 2 other individuals. So this was not just me getting involved with it, but a concerted effort of a lot of people that we knew and had relationships with that were interested in going out and making sure that State Question 788 was properly enforced and that the government didn't overstep, and that everybody who voted yes had their voice heard and got what they voted for. So that's why we filed a lawsuit. Nobody intends to stall the implementation. Yes, we've asked for an injunction. Some of that is lawyer language and the technical rules of pleading and how that we have to do things. We have challenged the entirety of the rules because the Administrative Procedures Act wasn't followed. However, all of those rules aren't necessarily invalid. So we've said alternatively, because lawyers like to plead alternatively. If it's not A, it's B, and if it's not B, it's C. We did that in our petition. So first we said it didn't follow the Administrative Procedures Act, but if you think that it did, the rules have overstepped, they've gone too far, and so they're arbitrary and capricious. And then at a third level, that they violated the Open Meetings Act, and that applies to both the first set of rules and the second set of rules. Excuse me. So that hasn't changed, but we really are only seeking to stop or limit the enforcement of those rules that are inconsistent with State Question 788. So our position is that yes, there are some problems with State Question 788, but that it does have enough that a regulatory framework can be put in place and that businesses can open. However, at the same time, I will tell you, we do have holes that need to be fixed, and that if that, excuse me, is put into place with the limited rulemaking authority that exists under 788 without the legislator acting, it's going to be more important than ever that anyone who is working in this business absolutely 100% be above board, follow the law, walk a tight line, because we don't need an Old West system. We're asking the government here to approve a product that is illegal federally, and there are concerns about that. And so whether we're talking about amending 788, implementing rules, or taking other action, everyone involved with this business and enterprise, whether you're a lawyer giving advice or somebody selling the product, has to be aware of compliance and not doing things to bring people down on your head and wanting to bring you in. It needs to be above board. And so that is one of the reasons why we're trying to work with the organizations to get some compliance and get agreements in place. Excuse me. So I'm going to start with the questions. And again, yeah, Jeremy, I am drinking the Quantum CBD water, but I'm all out. So if you want to bring me some to the office, that would be fantastic. I always appreciate it. I'm going to start out with some of the questions. And if people have more questions, by all means, post them up there and I'll do my best to answer. So Stephen McClendon says, State Question 788 says that one of the requirements for the 12 members of the Medical Marijuana Food Safety Board is that they be marijuana experts. Many of those named are not experts. Do we plan on adding this as a violation of State Question 788? That's in there. That was something that we challenged. The issue is, hi Cammie, I see that you sent an email. Did you send it to rachel@bussettlegal.com? If you didn't, make sure that you did. I will check my spam because I don't think I've seen your email. But let me get back to this. So, yes, the 12-member board was something that we challenged. First of all, they are overdue on that. That was supposed to be done within 30 days. That was not done. That was finally listed yesterday. So that's a violation. And under our interpretation of statute and the law, that in its of itself, that violation and failing to have it up within 30 days is irreparable harm, which justifies an injunction. The other side will argue that that's been cured by the listing of this board. However, I agree that the majority of these individuals on the board are not medical marijuana experts. The flip side to that is medical marijuana industry experts isn't well defined in State Question 788. So what that means to the state versus what that means to you or I are two different things. And so that's going to be where this is argued. State Question 788 is a great law, but it has issues, and it wasn't written by lawyers or legislators, and that's fine. The people should have the right to get out there and pass legislation through the initiative petition process. Excuse me. But when rulemaking is done or legislation is passed and you have to have rulemaking associated with it, like State Question 788 does, you have to have certain language in there that addresses the rulemaking authority, and you also have to define terms and that sort of thing. And that's some of what was left out of 788, and that's why we're having some of the problems that we're having today. Excuse me for 1 second. Sorry, sniffles are getting me. So, yes, the 12-member board is added in there. We had addressed it when we filed the emergency injunction. When we did our updated filing today, we added information in there about it not being done correctly. So, Ma and Pa's Organic Pot Farm, Little Organic Pot Farm, excuse me. They have a couple of questions. They are commercial growers, and they are planning to grow on their farm in Nowata. Can you give an update on our lawful ability to grow outdoors or in greenhouses, enclosed or open hoop houses? What type of fencing will be required? Where are we on the aspect of food standards? So let's talk about that. When we initially filed the lawsuit, one of the things that we said was that the Department of Health did not have the authority to dictate how grow operations were done. And A.G. Hunter actually agreed with that, and so that was stricken from the original rules. And we've gotten a lot of pushback for our lawsuit because we continued it even though they cut those regulations down from 70 some odd pages to 20 pages, and people said, well, what could be the problem? They're so much shorter, they have to be better. They are in some respects and they aren't in others. And one of those respects is with regard to food standards and commercial licensees. Excuse me, Rule 5-9 lumps all commercial licensees together. And so that's whether you're a retailer, a grower, or a producer, and says that you have to comply with certain standards of Title 63, and Title 63 is the Public Health Code. And so at first blush, it doesn't look like it's that big of a deal, but when you get out there and you look at what those food safety standards are, or what those citations are to those statutes that they cite, you realize that there is in fact a problem with that. The first one being commercial growers. They have applied these food safety standards and drug safety standards to growers as well as producers and dispensaries. You can't logistically, economically, realistically grow marijuana, in my opinion, although I'm not a farmer, but from everybody who I've talked to about who does this as a business, you can't grow it in restaurant quality conditions. And so that would appear to put us back to where we were before A.G. Hunter's letter, saying that it had to be indoor, that it had to be, fumes couldn't be smelled, you couldn't see it, you couldn't hear it. Basically, it was the dirty little secret inside the building. Well, 5-9 as it's written for growers puts us right back in that situation where it's the dirty little secret, where it's hidden, has to be in restaurant standard conditions. Nobody's going to grow marijuana in restaurant quality standards, and if they do, nobody's going to be able to afford it. So that's the first issue. The second issue there is they adopted an amendment after Mr. Durbin and I after Mr. Durbin and I went and met with Commissioner Bates on the morning of August 1st to try to clarify that, well, that only applies to the extent it doesn't interfere with State Question 788. Well, here's the problem. If you know anything about the three branches of government, you know that the role of the legislator is to pass the law. The role of the executive is to enforce the law, and the role of the judiciary is to interpret the law. And so state agencies like the Department of Health are members of the executive branch of government. So their job is to enforce the law. But the legislature can delegate authority for making law to a state agency, and that's how we get regulatory rules like what we have here. And when they do that, they normally have very specific language that would say, this agency is given the authority to make all the rules, regulations, etc. for implementing this act. That language wasn't present in State Question 788. What State Question 788 had some very specific grants of authority to the Department of Health. And because that's all that was in there, and there wasn't this general enabling language that says the Department of Health gets to go make whatever rules it thinks is necessary, the Department of Health can only act on the authority that it was given. And here, the legislature isn't the one who gave the authority. The people came in and acted in a legislative capacity. So the same rules apply. We didn't give them the authority to make rules on certain situations, so they can't do it. So as far as what are the rules on growing, I don't know what they are, because they appear to be that you have to grow in restaurant quality conditions, and I don't think anybody can do that, and that's one of the reasons why we're challenging them. And then additionally in there, those other rules, the reason I started talking about the legislative, judicial, etc. is important. When they add in this phrase, except to the extent that it doesn't contradict Question 788, well, do you know what that means? I don't know what that means. I've been a practicing attorney for 15 years. I went to law school over 4 years. Yes, it took me 4 years because I was raising 2 babies and working full-time, so I went part-time. Most people get through in 3 years. But regardless, so 4 years of law school, 15 years of practice, interpreting all kinds of complicated statutes, insurance documents, etc. I don't know what that means, except to the extent it doesn't conflict State Question 788. On its face, it doesn't directly contradict State Question 788, but once you start dissecting it, it conflicts in all kinds of ways. And so the way that I look at it is, y'all are put on notice by the virtue of the fact that something is a law. And so ignorance of the law isn't a defense. If you can't pull out this rule and read it and figure out how to comply with it, it's not putting you on notice. And if you have to read the Food Safety Standards Act, and then you have to read the Controlled Dangerous Substances Act, and then you have to go back and read this and then try to figure out what conflicts and what doesn't, you don't know, and I don't know, and I can't advise you whether it conflicts with state question 788, and you can't figure it out, and it effectively regulates you out of doing business. And that's a reason why we challenged particularly Rule 5-9. It's just not clear. You have food safety standards that they are applying to growers. Part of the issues with food safety standards is the idea of adulterated foods, meaning that you have something that has something in it that it's not supposed to. So I'm drinking water. I don't want to be drinking water that's got, dirt floating in it. If I had dirt floating in it, that would be adulterated. You're selling a product that is a food product. It can't be adulterated. You have to list on the labels all of the things that are in there. They have to be nutritive. Dirt in my water is not nutritive, and so if I'm adding a substance into my product that I'm selling that doesn't have a nutritive value or isn't a preservative or some other appropriate type of additive, I can't sell my product. It's considered adulterated. And so under those rules, it would appear that adding cannabis products to food would constitute the attempt to sell an adulterated product. At our hearing yesterday, Tuesday, because all my days are running together, the state tried to argue that we were talking about the ability to sell spoiled food. That's not it at all. It's the ability to take a product. If it's this glass of water and I want to sell cannabis water, it's the ability to label it as cannabis water and have it comply with the food safety regulations. It's the ability to say that cannabis is nutritive or doesn't take that out of line. It's that. The other thing is those statutes talk about compliance to the extent practical with the FDA food guidelines. Well, you're talking about selling a product with an additive that is illegal under federal law. So how do you comply with federal law? You can't, because it's illegal to sell cannabis federally. So what does it mean to the extent practicable? Do you know what that means? I'm a lawyer. I can argue about what that means. But there's no bright line standard that says this is the extent practicable. And then to what don't we have to apply to under the FDA rules? Just the part that talks about cannabis? Is there something else under the FDA rules that we don't have to talk about? That's why it's a problem. Same thing as it relates to controlled dangerous substances. You can't sell products that are controlled dangerous substances under the law that are labeled as marijuana or cannabis. It's not allowed under the rules. So do we ignore that? How does that happen? How do we deal with that? So those are conflicts within those two sets of rules that you're applying to one specific product. So if this is my cannabis water that I want to sell, and it's water that I've added cannabis to, and it's not clear that cannabis isn't an adulteration, I have that as an issue. And if I have this water that now I'm labeling as cannabis water, it's violating the Controlled Dangerous Substances Act, because we're not supposed to sell products labeled cannabis, and then to the extent that they don't disqualify with 788, well, there's nothing in 788 that says I can or can't sell cannabis water. So how do you know whether or not you can sell cannabis water under that rule? You don't. You can't understand it. That's where that fancy term arbitrary and capricious comes in. Nobody knows what it means. Nobody can understand it. What are you doing? The Department of Health has the ability to regulate food standards. That goes back to the Food Safety Board. They should implement food safety standards. 788 requires them to implement food safety standards, but they can't just wholesale adopt other statutes. They can start with those statutes as a basis, and they can bring those in and they can modify them so they apply appropriately to the cannabis industry, but they can't just pull them in and say, all of these apply except to the extent that maybe they're contradictory, and then they don't apply, and then tell you, good luck, go figure it out. So there we go. I'm going to scroll up here because I thought I saw some questions that I want to address. Luke says, I don't like the bona fide relationship a patient needs It says with a patient, but I think you mean a physician. Marijuana clinics are making people pay for 2 visits instead of just 1. So, Luke, that's something that we challenged too. And I was actually, part of the reason I was running a little late was I was listening to the Department of Health's presentation from yesterday, because I wasn't able to be there because 1, I was sick, and then 2, I just had some other stuff I had to take care of in my legal practice. And one of the things that I thought was very interesting was that Commissioner Bates said that the various agencies needed to stay within their own lane. And that was pretty funny to me, because the Department of Health did not stay within its own lane in writing these rules. The Department of Health went into all kinds of lanes. They went into ag, they went into physicians, they went into safety in other areas that they aren't supposed to be. And Commissioner Bates talked about the fact that State Question 788 talks about the reasonable medical standards that applies. That's right, reasonable medical standards apply to the physician-patient relationship. The Department of Health doesn't have the authority to regulate that. 1, because the plain language of State Question 788 doesn't allow it. 2, physicians aren't regulated by the Board of Health. They're regulated by their own regulatory industry, just like attorneys are regulated by the Oklahoma Bar Association and our Board of Regulators. So using that as an example, one of the first things that happened was when this passed, there was a meeting of the Professional Responsibilities Board to talk about how that impacts the rules of professional responsibilities for attorneys. And so consequently, if you come into my office and meet with me, I make you sign a waiver that has all of these things that the bar says that I have to talk to you about and advise you about, in giving you advice on practicing and being involved with this industry, because it's legal under state law, but not legal under federal law. And so that creates issues. It creates a possibility whereby the feds could determine that you and your lawyer are involved in a criminal enterprise, and the attorney-client relationship that you rely on in getting advice could go away if the feds want to say that you're co-conspirators. So that's an issue, and that's something that we have to advise you about. But the Oklahoma Bar Association and our regulatory agency is the one that came up with that rule, that issued that rule, not the Department of Health, because the Department of Health doesn't have regulatory authority over me as an attorney. Likewise, they don't have regulatory authority over doctors, which is why all of those rules went away, but they're still trying to sneak in a few of those rules. And that's part of what we challenged in the injunction. They don't have the authority to do that. So, Luke, I hope that answers your question. We'll scroll up here again and look. Chance, I've been retrofitting a mobile home to be my first indoor grow facility. Can they stop me? The first set of regulations said I had to have a concrete floor. Can they deny me doing this at that point? That's a good question. Again, if you were here when we were talking about the new regulations, that's a question. Nobody really knows what that means, so I can't particularly tell you. There are rules in there that say you have to comport with reasonable building structures and standards. That's probably outside the scope of their authority of what they have the ability to say, but it's also something reasonable. So you are going to have to comply with some sort of building safety standards. Whether it has to be a concrete floor or not, I don't know. I'm not an expert in building safety, and so I can't really advise you on that. Luke wants to drink all kinds of cannabis products. You go, Luke. You let me know when that comes out. Jeremy, yes, the video should be public. It's on the business page, so everybody should be able to see it. Required follow-up visit after the doctor recommendation. Again, that's something that we challenged. Hold on one second. I'm getting a text. All right. Scroll up here. Are other states able to label their products as cannabis? Yes, they have to label what's in it. There has to be truth in labeling. And so they do that by writing state regulations for labeling cannabis products. They don't just wholesale adopt others. Linda says, I can't get my doctor of 10 years to do it. He is convinced he has to take a class first. Well, Linda, I don't know that I'm going to be able to change your doctor's mind. I've met a lot of doctors. I've not been able to change their minds. They usually kind of think that they sit at the right hand of God, and they know as much as other folks. But those rules saying that they have to take a class have been done away with. That was part of what was taken out of the first set of rules. I don't think that they have to take a class, but your doctor does have the right to refuse to write a recommendation if that's what he wants to do. Daniel Robinson says, is the MDDO part of the language being challenged for physicians? Yes, that's part of the challenge. Matt, I'm not sure what you're saying that said that they needed training, not 788. Cindy asks, I'm from California and I made products for a dispensary and we are able to mark and classify edibles, vapes, and wax as cannabis. I think she was answering a question. James asked me to talk about the regs made by the Department of Health as well as our current lawsuit affects the standards on that. Again, if you didn't hear it earlier or if you didn't understand it, we challenged the rules under 5-9 applying specifically to growers that commercial standards can't be, commercial restaurants food quality safety standards can't be applied to growers. That's just unreasonable. That would be arbitrary and capricious. And frankly, Commissioner Bates admitted to me and Mr. Durbin and my associate Kelly Hensley that those weren't supposed to apply to growers, and he knew it on the morning of August 1st, and they had an opportunity to fix it and change it. And we, in fact, asked them to wait on voting on the rules on August 1st so that we could all sit down and work with them about the things that we had problems with beforehand so that we could avoid further lawsuits, and they didn't do that. How's the Damon rule playing out? I don't have a good answer for that for you. But I will get back to you. Cindy says California has none of these regulations. Oklahoma politicians are trying to control everything. Cindy, welcome to Oklahoma. Nobody has to use their regular doctor. You just have to have a appropriate medical relationship with your doctor. Home grow outside. Can that happen with a nosy neighbor that can see over your privacy fence? Well, that's not real clear in the rules. Let's talk about the fact, have you ever heard of what's called a nuisance? A nuisance is something like a swimming pool or a pump jack. It's attractive to other people, particularly kids. And if you maintain a nuisance, the law requires you to do certain things to secure it and protect it. And so the argument under the law basically is that homegrown marijuana creates some sort of nuisance, and so you have to keep it. In my opinion, if your nosy neighbor wants to look over your 6-foot-tall privacy fence and complain about seeing your weed, well, what did he expect to see? He's looking in your backyard, and he needs to keep his eyes on his own paper, for lack of a better comparison. We can't keep everything shielded from everybody else. You have to take reasonable care. If you're growing out in your backyard, maybe you need to lock your backyard so not everybody can go out there and get access to it. Take care of it. At the end of the day, it is a federally controlled illegal product. You don't just want it getting out there where anybody can get it, because in addition to basically inviting the federal government officials into your house to do a search and violate your Fourth Amendment rights, you're opening yourself up to liability that you don't want to have. If somebody comes in, steals your weed, smokes your weed, goes and has an accident, and hurts somebody else. Those are all issues that we have concerns about. So if you're doing it at home, take reasonable precautions. Think about it. Think about what you would want to see, how what you're doing affects other people, and act reasonably and appropriately would be what I have to say. Deb, I get what you're saying about low income, fixed income. I didn't make the rules on that. The rules have to change. Nikki Weed Gossett asked, do doctors who provide the recommendation need medical record or proof of cannabis use, or just to show medical history to show a need for medical marijuana? Again, this is that reasonable medical care. 788 says you don't have to have any kind of condition. Other states say that you can only be prescribed medical marijuana if you have certain conditions, certain kinds of cancer, epilepsy, etc. Oklahoma law is very broad on that subject. You don't have to have a specific condition. So if your physician, after examining you, doing your history and all of that, determines that you have a condition that in his opinion is appropriate for treatment with medical marijuana, and he wants to recommend it for you, he can. It doesn't have to have, you don't have to have a history of medical marijuana use or marijuana use at all. You have to have a reasonable condition that under the appropriate standards of medical care qualify for that. And Commissioner Bates talked about that being a vague standard. Unfortunately, it's not really a vague standard. You look at, in the law, the standard for reasonable care in the community, and we look at that day in and day out in the practice of law. If you do a medical malpractice case, if you're going to go sue your doctor because he cut off your left leg when you're supposed to have your right leg cut off, you talk about whether or not he followed acceptable medical standards for the community. And if he didn't do that, then he's liable. He's negligent, committed malpractice. And so the same sort of thing applies here. You apply reasonable and appropriate standards for your community as to how we examine people. And that standard actually differs a little bit from location to location, because how we do things in Oklahoma is different than how they do it in California, as we've already talked about, versus Colorado, versus New York, versus Maine. Every state's a little bit different based on their own state laws and access to technology and information. And physicians know what that means, because that's part of their specialized knowledge, education, and training. They don't need a legislator to tell them what is a reasonable and acceptable medical standard. Let's see, where are we at? No, Dan, the doctor does not have to take a class under the current rules. Chantel asks if the forms are final and available on the website. Well, on the website, you don't have any applications. What you have on the website is information for applications. Then you have a doctor form for your doctor to write the rec on. You have a caregiver form, and you have a withdrawal of a caregiver form. You don't have a patient application. You don't have a temporary license application. You don't have a grower, processor, retailer, or transportation application. So there's no applications available online, so they can't be in their final form because they don't exist. Any projection, Matt asks, on the finalized draft date, and will it be posted? Matthew, are you asking me about the application dates? I think they said they would finally have application dates on August 25th, but I saw something yesterday that indicated commercial license applications might not be available to September 25th, but I can't find that now, so I'm looking for that. Bobby Lee, I don't know what you're asking about having kids in the house. Give me a little bit more specific, please. Richie asks, could the feds go after doctors? Yes, that's one of the things that they threaten all the time, is that if they're writing recommendations, that they're going to take their narcotics scripts away, writing ability away from them. Cindy, one of my understanding is that this law was written for the idea of telemedicine, but they don't want you to not have a relationship with their doctor. I frankly have a problem with not seeing a doctor in person for them to examine you for prescribing something like this, whether it's opiates or marijuana. I think if you're being prescribed a controlled substance that's potentially hallucinogenic, and THC is hallucinogenic, then you should be seeing a real doctor. You should have a real relationship, because that benefits you as a patient from having some quack who doesn't know what they're talking about. And I know you're talking about the situation of marijuana and you don't see it as that big of a deal, and I understand that as well. But we really do want people to have a one-on-one relationship with their doctors. Yes, Dawn, I do need somebody here helping me with my questions. Why aren't you with me? Matt, I don't understand what the proposal you're asking about is. If you would please type me a full, complete question that I can answer, I will do my best. What's going to happen on August 14th? What is August 14th? Oh, August 14th is the due date for the state to respond to our motion for emergency injunction. I'm sure they're going to write something that says, we fixed it all, it's moot, their lawsuit is crazy, and you should dismiss it, Judge. So that's what I anticipate will happen on the 14th. Okay, Dawn is saying, Bobby Lee, the rules about children present, even with oils, edibles, etc., is that part of the change we're saying needs to happen? Well, if you're asking me, if you can pop your Loratab while running your kid around town and watching them at home, you should be able to eat your sucker. Safety of kids isn't about whether or not you're medicated, whether it's taking an opiate or taking an edible or even smoking a joint. And let me tell you, I spent plenty of time as a kid around people who were smoking joints, and I turned out okay. Now, does that mean it was great and safe all the time? No, it doesn't. I will tell you, there were certainly times that I was unhappy about the situation that I was in, and I was aware of what's going on. But usually there were more impairing substances happening than somebody just smoking weed, and usually they weren't doing it to medicate either. So with regard to that question, I think there has to be some sort of balance stricken. You have to be reasonable, you have to make safe decisions. But if you're having to take medical marijuana to control a condition, whether it's epilepsy or migraines or pain or whatever, you can take those. You can take an opiate to control similar types of situations. Then you should be able to use marijuana in moderation. But that's my opinion. Also, there are now drugs released that have marijuana bases in them for controlling of epilepsy, and to the best of my knowledge, there's nobody saying that you can't take that and be around your kids. Dawn says she's not here because she's in her jammies. Dawn had a rough day. She lost one of her fur babies to the Rainbow Bridge, so I'll forgive her this time. What happened in court on the 7th, Regina asked. What is the next step, and how long will it be before a decision is made? Well, on the 7th, we appeared. The day before, they filed a motion to strike based on what's called mootness, which basically is the idea that the rule changed made what we filed invalid. We argued that it didn't because those procedures still were violated. We also argued that we challenged the entirety of the rules, and they didn't fix the entirety of the rules. They only fixed certain things that we particularly complained about, but we had greater arguments than what was particularly complained about. That is also why we filed the emergency injunction that day, to bring it in line with the new rules and address everything that we could think of that we had a problem with. So the court did not issue a emergency injunction that day. The court felt like, after reviewing the emergency injunction statutes, that he had to give them additional time to reply. So that's what he did, but he also recognized the urgency, especially with the August 25th date coming up. So he ordered them to file their written response by the 14th of August, and then we have 3 days after that to file a reply. So that means on the 15th, 16th, and 17th, I'm going to be really busy and probably not taking appointments because we're going to be doing a lot of writing. And then we have a hearing on the 21st. And on the 21st, what could happen? He could grant it, he could deny it, he could reserve ruling. I anticipate he will probably issue his ruling on the 21st because he knows that this is a priority. This is a judge that I really like and respect. That was part of the reason we elected to file it in Cleveland County. We could have filed in any of the counties where we had plaintiffs, and we looked at all of those different options, and we decided Cleveland County was where we wanted to file it. 788 had great support there. We felt like any of the judges that we would draw would be somebody who would be thoughtful, informed, and listen and consider the issues without rushing to judgment, and wouldn't let any personal beliefs stand in the way, because while judges are supposed to put that aside, we all know that personal bias, whether we intend it to or not, can come into play. And so that was very important to all of us as we were deciding where to file it. Can I write something to protect the doctors from the feds? Not unless I know how to change federal law or have the ability to change federal law. I don't do that. Or I don't have that ability, Richie, so I can't really do anything from them. Hey, Giddy. He was late, but he was running around with me today. I took him on a meeting to Tulsa and made him go talk to some people. Joey asked if they change the legislation and conditions and no longer qualify, will we get to keep our license or will they take them away? That's a good question. I don't know the answer to that. If I was your lawyer, Joey, I would argue at a minimum you got to keep it for the 2 years that your license was granted for. And then I would argue that you were grandfathered in, and since you had it, you get to keep it. But the judge might disagree with me. That should be something when they draft new legislation that they would have to address. My mom's doctor told her yesterday that if you recommended medical marijuana, he'd have to take away her pain medicine. That is not my understanding, but that is not my area of expertise, and we would need to talk to a doctor who knows a little bit more about that. There are very strict regulations on pain medicine, and I don't know if we're talking about a pain management clinic as opposed to a GP who's giving the prescription. So, Ronnie, that's not an answer that I can specifically address for you right now, but I can see if I can find some information. Excuse me. Low-income people, do you have any idea what the prices will be in the dispensary? No, I don't. Those are independent businesses, just like going to Walmart or Crest or Walgreens. Everybody gets to set their own price, and so whatever price they want to set it at, that's what it's going to sell for. Nikki asked, Tom Bate appeared to be pretty vague in his answer. Well, he's always pretty vague in his answers regarding required pregnancy tests, and seems could defer to legislation to implement it. Is that likely? And if so, is that equally likely to be challenged? Yes, Nikki, I think that's something that's likely to be challenged. That's what we call an equal protection violation. That's a discriminatory testing based on sex. That's putting more tests on women than on men in determining whether or not they're eligible for medication. Opiates are prescribed all the time for people who are pregnant, and they're given the appropriate warning, and I think that's an interference with the doctor-patient relationship and privilege. And if they do that, that's something I'd be happy to talk to somebody about challenging, because I think that's wrong. Hey, hooligan. Oh, Linda asked how DHS is. Well, Linda, how is DHS? We all know DHS is my favorite state entity. DHS is supposed to be concerned about child safety, and if it doesn't create a safety risk, they're not supposed to be taking away your kids. But I know a lot of people who'll tell you that they've had their kids taken away for things that don't qualify as safety risk. So that's something that we're just going to have to look at. I will tell you, I talked with an attorney in DHS court, and she told me that she anticipated that they were going to treat medical marijuana just like other medications. They were going to be looking for evidence of addiction, and they would treat it like anything that was otherwise legal, like alcohol, or prescribed like an opiate. And if there was evidence of addiction or dependency and creating a danger for the child, it would be addressed in that way. So we're just going to have to wait and see how that works out. Dawn Gregg is one of my plaintiffs, is a former DHS worker, and that's part of the reason why she wanted to be involved with this litigation, is helping to figure all of that out and help to set precedent for people, because we know lots of people that will be affected by DHS and medical marijuana cards. Joey, they might add in qualifying conditions. I can't tell you that they won't. And so that's where you get into the idea of who you're voting for and what they're voting for, and make sure you exercise your vote accordingly. As a judicial candidate, I can't tell you who to vote for. I can't tell you which party to vote for. I will tell you that no matter what you're looking at voting on, I encourage people to really get to know the candidate that you're voting for or against, and make sure who they are as a person and not just the party that they're affiliated with, because I think part of the problem that we have here in our state as well as in our country is when people vote party over platform and over the individual, and I think that was a lot of the dissatisfaction that we had in our last major election in 2016. You heard people talk about they didn't really like either of their choices, but they voted anyway. Well, think about research and make an informed decision, and then when they act against your will, make a better informed decision next time and make your voice heard. Y'all have been part of a great grassroots movement in getting this passed. I had a conversation with somebody in 2014 when I was standing on a ranch in Wyoming when there was word coming out about gay marriage being voted on and ruled on by a appellate court, and I said, in Oklahoma, gay marriage will be legal before marijuana, and they looked at me and they laughed, and they said, really, why do you think that? And I said, because the courts are going to make gay marriage legal, and the legislature or the people have to make marijuana legal, and the legislature is never going to make it legal, which they proved, knowing that this was going to pass, and they complained about the law all the way through, and they had the opportunity to create laws to address the issues that we're looking at now in the last legislative session, and they didn't, because in my opinion they wanted to say, oh, we had to fix what was voted in by the people because they didn't know what they were doing, instead of just doing it right the first time and then risk having what they did subject to review in an election. But that's just my opinion. Kimberly Thomas asks who the judge is. I assume you're asking about who the judge is in the case. That's Judge Tupper. He's a great judge. He's a fairly new district judge. These have to be heard by a district judge. Previous to that, he was a special judge. Had drug court, family court, I believe probate, deprived, delinquent, that sort of thing. Well, he might not have had delinquent, but I believe he would have sat on some deprived cases, and I can tell you every time I've appeared in front of him, I've always found him to be fair. I found him to be somebody who listens to the arguments and gives a lot of thought before making his ruling. So in that regard, I couldn't be happier with who we were assigned as a judge, win or lose. I feel like we'll get a fair hearing. Are we expecting 788 to lose momentum due to the lawsuits? I'm not sure what you mean lose momentum. 788 is the law. The lawsuits are about the rulemaking that has been undertaken by the Department of Health. It's not about the law. The rulemaking has attempted to circumvent the law, in my opinion, and they're trying to do by regulation what they can't do by legislation and didn't do by regulation. So Lindsay said, Ron Dermond said he filed something to have your cases combined or moved to the same county. Can you explain this? It is a strategy to work together for a common goal. So what Ron Durbin did was he filed a motion for an intervention, which is basically saying, let's say Lindsay, he represented you. It would be Ron saying, hey, court, I represent Lindsay, and Lindsay has an interest in what's going on in this lawsuit, and we didn't file this lawsuit, but we think we should get to be a part of this lawsuit, and whether there's permissive and there's mandatory intervention. And so he filed for permissive intervention, which means they're not, that the individual that he required or that he filed on behalf of isn't required to be part of the litigation in order for us to have a proper outcome. Hold on, all my dogs just walked in here. Come here.
Hey.
They can stay. Just close the door. Thank you. Hi, Ray. Hello. This is Ray. So he moved to intervene and asked to be able to argue. There was discussion about doing that. Ron's lawsuit is just primarily on the Open Meetings Act in Oklahoma County. He wasn't getting rid of that, partially because the Open Meetings Act requires that it be brought in the county where the violation occurred. And so therefore the actions that the Department of Health undertook occurred in Oklahoma County. So that has to be in Oklahoma County. We filed under the Administrative Procedures Act. After further discussion between the lawyers and the parties, Ron agreed to withdraw his intervention. That requires the, he's not in our lawsuit, and there are particular reasons why we want to keep those separate, and that falls under that attorney-client privilege and work product thing that I told you guys I wouldn't give you any information about, because the other side will probably listen to this. And so just know for various reasons we've decided that those should be separate. But yes, we do have common goals. We are cooperating and working together. He helps me, I help him. We talk on a fairly regular basis, as well as working together in the working groups, but our lawsuits are staying separately. Jordan, what are the chances they actually enforce federal law and begin taking guns and turn them in from people? So are you asking me whether the feds are going to come in? I don't think the feds are going to come in. I don't think the feds are going to come in unless you're doing something that really gets the attention of the federal government, but I can't tell you that that's going to happen. It's a violation of federal law to purchase a firearm if you're addicted to something, or if you have a medical marijuana license, because it's illegal under federal law. They could come do it. You have the issues of state law. One of the things that frustrates me every election cycle is the hype about the Second Amendment, and we can't elect this person or that person because they're going to steal our guns. Well, the Second Amendment is great, but every state, and I'm not advocating against the Second Amendment, please don't think I'm saying that lightly. The point of this is that every state has a version of the Second Amendment. So you have the right to keep and bear arms under federal law, and you have the right to keep and bear arms under state law. And so the Supreme Court can only deal with your rights under federal law, and Congress can only deal with your rights under federal law. And even if Congress takes away your rights, states still have the rights to regulate gun ownership, gun purchase, etc. And so you still have those rights. And I know there were some concerns about OSBI saying that they were going to come in and take your guns, etc. I think they're getting into a very sticky area, and that's not something that they ought to be looking at doing. I think they've got bigger fish to fry and bigger crimes that they need to be looking into than coming in and taking a gun from an otherwise lawful gun owner. You can purchase a gun in Oklahoma by buying them at a gun show, and you don't have to go through the background checks, and you don't have to sign off on that box. You can purchase it from somebody who's selling it over the internet, or an individual. Is there a risk? Yeah, absolutely there's a risk, but you have gun rights, and if somebody comes and takes your gun, give me a call, because like this goes, that's an interesting challenge to me, and I like fighting those fights. So if I can help you, I will. Brandon says he's on supervised probation as well as in trial reunification with DHS. I'm sorry, brother. If I get my recommendation currently being in the middle of a case and on probation, will it hurt your case? I can't tell you if it's going to hurt you or if it'll help you. I will tell you that it'll be something that everybody will be talking about, and you need to be prepared to deal with. For more specific advice than that, you would need to talk to your attorney who's helping you on that, or if you don't have an attorney and you want to hire one, we do handle DHS deprived cases and would be more than happy to talk to you about it. Let's see, what else do we have here? Eric, you're welcome for the updates. Thank you, Hooligan. I'm trying to knock them down. James says he's seen the news that Tom Bates is pushing for a special session. What does that mean for the lawsuit and the working group? Is he trying to pass the buck? Well, what does it mean for the lawsuit? It depends. It depends on what happens in a special session. If they come in and they fix everything and they do it right and they don't pass these inappropriate laws, then we all go away quietly and we have a great medical marijuana program like the people of Oklahoma voted for, and people are creating a thriving cannabis industry and they are using their cards and doing what they were supposed to do. If the legislator does it right. If the legislator does it wrong, whether it's this lawsuit or another one, we continue to challenge things which violate the state constitution or the federal constitution or other laws. The fact of the matter is we're the 30th state, we're the 31st, depending on how you want to count. DC, which is regulated by the federal government, so I don't exactly understand how they're getting away with having marijuana legal there. And that's in my spare time, which I have very little of, but something that I'm trying to study to see how they're doing that, how they're comporting it with federal law. But regardless, the lawsuit might go away. Is he trying to pass the buck? Maybe a little bit. I think he doesn't want to be the one who's on the hot seat and loses his job over all of this. I think he knows, based on those memos that we've seen floating around that Giddy and I talked about, that I talked about with Fox 25, and that we saw again yesterday from the OMMA presentation. Here's some screenshots of them. That there was, well, I have a word for it, but I won't use it here. There was some hinky stuff happening in the background with all the state agencies, and that's something that we're investigating and we're not going to let slide by. So we anticipate coming at you later with some more information about whether it's corruption or wrongdoing or whatever you want to call it. We're still investigating. Have there been any changes in the doctors that can write recommendations? Under the rules, David, or under the proposed legislation that the working group is working on? I need you to specify a little bit more. Don said hi to Pig. Yeah, Pig was in here for a little bit, Don. He went back outside. Ray hung out with me for a while.
Oh, he's back. And he's back.
Oh, come here, Pigster. Come here.
The only one who can open doors.
This is the pig. He oinks, so that's how he got his name. He likes to say hello.
He wants back out already.
Yeah, he wants out. I like misfits, and Pigster is a misfit. He's a pit bull that we think was maybe used as a bait dog because he had a broken leg and he was a foster fail. So, Nikki says, can 788 rules and regulations change with the governor? Well, the governor doesn't regulate 788. 788 is legislation. It created 8 statutes. It starts at Title 63, Section 420. I don't know if that was intentional or what. It's a little funny. But anyway, there are 8 statutes that are created there. The legislator can always modify those statutes, add more, etc. That's what the idea of the special session is about. And so can the governor modify it? Well, she can veto the modifications, and then the legislature can do the legislative override. But she can't per se. The people who you vote in when you vote for your House of Representatives and Senators, those are the ones who will change 788. So if you don't like the stance that they take and how they tell you that they feel about it, you don't feel like they're going to listen to you. Again, you're voting for a person. You're not just voting for a party. And it's like hiring a lawyer or hiring a doctor or anything else. We don't always like the profession. But you got to learn to like the person. And for me as a lawyer, one of the things that people tell me all the time is, you don't seem like a lawyer. I take that as a compliment. I pride myself on not being a lawyer's lawyer. I'm just like an everyday person. I just worked real hard to get here. So the regulations, those can change at any time because that's done through the rulemaking authority, and that's done based on the enabling language that we're given to them. And so those individuals who are on the Department of Health board, well, those are appointed by the governor, and so she does have some say there and push and pull with them, although that's all done behind the scenes and you're not supposed to know that. That's one of those little secrets of government. So you have to really remember what you were taught like in 8th grade American government class on how a bill becomes a law and how administrative rulemaking works. It's important stuff for everybody to know because it really does affect your everyday life. Since it's still Schedule 1, anyone who is a part of a group who is funded or semi-funded federally, like Oklahoma Bureau of Narcotics or a tribe, shouldn't be able to sit on the board. Are you asking me or just telling me that, Chad? I'm not quite sure. Pegastar is sitting outside the door watching. Thank you, Midnight. You're welcome. I'm currently a felon for cannabis, graduated drug court because of it. Is it possible to get off my record? David, I don't know. I'd have to look at your record to tell you for sure where you're at and everything. You can have a felony expunged, but I don't know if you pled guilty or if you, and you were convicted or if you did a deferred sentence. All kinds of stuff I need to know. So we can happily help you with an expungement, or if we can't do it, we can get you to an attorney who can. So feel free to give my office a call and we'll talk to you about it. There's never really a charge for consultations. For most cases, we do charge for some. Like we are charging a small fee for consultations if people are specifically wanting to get involved with this lawsuit because it takes an exorbitant amount of time, and I probably have well over $50,000 or $75,000 worth of man hours in it that I'll never get paid for. But again, I'm not doing this because it's about earning big money. I'm doing it because it's the right thing. Yes, Johnny, I agree. Those 12 people, for the most part, are stacked against 788, and it does not comply with 788. We're talking about that in the lawsuit. If you are on probation, can you work in a testing or growing dispensary? I don't recall reading anything that says that you can't, but I wouldn't be surprised if they don't start showing up in the rules of probation about what you can and can't do, because they usually say that you can't be around convicted felons or around people who are using controlled substances and the like. So the important thing to remember is there are 85 statutes or 85 titles in Oklahoma statutes, as well as all of the statutes that fall under each one of them in the Oklahoma Constitution and all the other Oklahoma regulatory rules. It's like everybody, when these rules passed, like that went out of their head, and suddenly we only have the 8 statutes created by 788 and nobody knows how to function. All of those laws still exist and they all still have to work harmoniously together, and we have to figure all of that out. Oh, thank you, Denise. Pretty dogs. I have 3. I have Pig, and I have, who you saw is the Pit. I have Chewy, who hasn't come in here. He's super emo. He's like a German Shepherd Golden mix. And then I have Ray, who is a Border Collie Pointer mix. She would be a great hunter. She loves to go up on point, but we don't really hunt, so she doesn't get that worked out of her. I'm looking. Jonathan, thanks for the information on DC. I need to look that up. You want to PM me some information on that? I would love it so I can go do some digging. Yeah, Chantel, because the Republican primaries are closed. The Democratic primaries are open. So if you're registered as an independent, you get to vote in their primaries. If you're registered as a libertarian, you do not get to vote in their primaries. I've had some people tell me in Oklahoma it shouldn't matter what party you're actually a member of if you register as a Republican, so you can vote in their primaries. That's where your vote counts the most. So take that for whatever you think that's worth. Lindsay, should somebody on a fixed income and rents and can't home grow spend the money for a doctor recommendation or a license if there are no dispensaries? That's a call that you got to make on what you're willing to do within and outside of the rules. I'm not going to tell you what to do there, and you wouldn't want me giving you that kind of information over the internet. If you have a question, give me a shout. People voted on 788 knowing a special session was going to be called to write the rules and regs. We need a special session. Hi, Pigster. Oh, they're back. They can open doors.
And here's the shoe.
Oh, Chew's in here. So,
Oh,
since we saw him, we'll give you a shoe. There's all of them.
Well, Chew, come back here.
Hi, Chew. Say hi.
I miss his fur.
Yeah, so those are all my dogs. Ignore my messy office. It's vastly cleaner than it was.
Guys, get out.
So should a special session be called? Probably. We really need it to clean up some holes, but it's not necessary. So,
One more. Dogs.
can anyone join the lawsuit? Right now, Cindy, we're really only looking for people who want to help contribute to cost, because it does cost a lot of time and money for us to do this. We're not trying to exclude anybody from the lawsuit. But because it's not to recover monetary damages, I'm not going to win a pot of money that can be distributed around to other people. There's not really a benefit to adding a bunch of people to the suit, and then it gets cumbersome because then we got a bunch of people who are having to make joint decisions, and we're more likely to get into a conflict situation. So, but we are accepting donations. There's a couple of different groups, I think, that are setting up donations to help fund the lawsuit. If you have a business, we are taking people on who have business interests because we don't have a big business representative in there. And part of what we're trying to do is have somebody from each group affected by 788 and the rulemaking a part of it. So we have a doctor on there. I wouldn't mind having another doctor. We have 2 dispensaries. We have 1 grower and processor, so I would be interested in having a grower processor come in. But again, if those individuals are coming in, we are asking that you make a contribution to the cost, because it is, like I said, quite expensive.
Sorry,
So Clinton asked, what happens if they go over the grow limit? That's a good question. We don't know, because they didn't put any rules in 788 on what happens to you if you're growing and you have more than 6 seedlings and 6 mature plants. There's no authority for the Department of Health in State Question 788 to write a penalty. So we get into the question about these other laws under the criminal statutes that go into effect. Do those interplay? Are we talking about the $400 misdemeanor, and what does that mean? That's one of those holes in the law that really needs to get fixed, either by giving somebody proper rulemaking authority or enacting a statute. David asks, what's the next big date? The next big court date is August 21st. Like I said, the defendants have to respond on the 14th. We get a reply on the 17th. I'm going to, if somebody who is smarter than me, knows better than me, can tell me how to put the pleadings up for you guys to look at it, besides going to OSCN, which I know some people are familiar with and some aren't. And Cleveland County doesn't always put everything up there. I'm happy to put it out there. We're trying to be as open and transparent about everything as we can, while also not working my poor ladies at the office to death, trying to answer everybody's questions. So if somebody will tell me how I can post the pleading on my Facebook page in a PDF form, I will happily do that. Oh, Dana, thank you. That would be amazing, and I wouldn't even know how to say thank you enough for that. We do have a lot of people who are working on this. Just so you know, you see my face a lot because I'm the firm owner and I'm the one that goes to court. But I do have a team of people working with me. I have 5 associates who work at my office who help on this in a lot of different manners. I have 3 staff people who work. Plus, I have accumulated a group of other attorneys who are interested in learning about this business and getting out there to help you guys be your attorneys, represent you, because even if I had the ability to do and help all of you, I physically can't, and there will always be conflicts because at some point you guys are going to get into a fight with one another, and I can't be on both sides of that. So we're trying to work with and train other lawyers who are interested in this, and that's something that we're doing. So while you guys see me, and I'm blessed to have all your appreciation, there really is a whole team of people that goes into making this happen and who make it possible for me to go do this, including my 4 crazy kids and my husband who support me in doing this. And here she's waving over here.
Hi.
That's my daughter Madeline. She's a sophomore at Washington and Lee University in Lexington, Virginia, and is home for the summer, and she got drafted into doing some running for you guys and reading and doing some stuff. Could legislatures straighten out and kill 788 after the elections if they wanted to? Could they render it as good as dead? Yeah, after the election they can come back in January, February, when they go back into session, and they can vote on it, they can amend it. It's a statute. That's why there's 796 and 797 that are constitutional amendments, which make it a lot harder for the legislatures to undo. There are problems with that. In the constitutional amendment for medical marijuana, it has specific condition restrictions, and so I'm kind of the opinion that there really shouldn't be condition limitations, because I believe that the government should stay out of my doctor's office, and it's none of the government's business what I'm diagnosed with or why my doctor prescribes me something. And so dictating what medications can be prescribed for which conditions is really none of the legislature's business, is none of your business, and how you're prescribed is none of my business unless you come to me and ask me about it. So yeah, they could go make it as good as dead if they wanted to, and then I would hope y'all would go get them unelected. Giddy has a page up. Dana is one of the clients that came on extra, and she is raising money to help pay her part of the attorney's fees and help pay into all of this separate and apart from what Giddy's doing. So we've got a couple of different things we need to figure out if there is one way to uniformly do all of that for the fundraising, but different people reach different areas. So Dana, I'll talk with you about it. We haven't had a chance to talk about that. Thank you, Chantel, for the compliment on the dogs. James is also helping with the fundraising. James is one of the people that has added his name to the situation and is on it. So, Chance, that's the question. Can they change the rules? In theory, you should be grandfathered in, but if the law changes, if the rule changes, you have to be, you can't just flagrantly disregard the law. So some of it's going to depend on how they write it with grandfather clauses and retroactive legislation and that sort of thing. Cindy, no, you don't get to decide any of those rules and regulations. That's what the Department of Health is for. They voted on them. They picked them, and your governor signed off on them. She said that they're good and right. So the only say that you get them is filing a lawsuit and challenging and protest like what we're doing. Is there a special session in February? No, back in February. If you go in February, they're back in regular session. Yes, they can go back in and butcher it. Giddy folks are asking you to post your fundraising link here or post it on the firm page or something. HIPAA laws should protect the patient. What are you asking? HIPAA prohibits, many people don't understand what HIPAA does. Health Assurance, Patient Portability, Accountability Act, something like that. I don't remember exactly what HIPAA stands for. Basically, if you're a medical provider under HIPAA, you're prohibited from releasing information unless the patient specifically authorizes it. And you're authorizing the release of information all the time. Hold on one second.
Sounds like we got a couple child robots in the living room.
Okay, sorry. My phone's blown up. I had to check a few things. Hey, Tim. Thank you, Linda. Thank you, Lindsay. All right, we got kind of to the end, so I'm going to go back here and see if there's anything in these questions that were submitted to me. What we can talk about. It says in here, additional working group meeting yesterday, posted suggestions from interagency committee that will all but kill small business owners. Yeah, I agree with you. That's this, hold on, I don't want to drop this iPad. I just got it. Last thing I need to do is break it. They'll get mad at me. So this, some screenshots of that interagency memo. Giddy and I talked about the one that was from 6/25. It's clear that they were working on doing this well before any of this went into effect. Registering, oh, okay, so Billy, I think this is from Billy Dunn. He posted on through Hooligans page. He said, what's up with registering with the DEA? I know that's what's in the August 26 regs, but is that something we plan to address? Yes, we address the OBNDD registration. We don't think that BOH has the authority to make you do that under the enabling language. And then we have the issue of this new registration not taking or going into effect under this new law until November 1st. So one thing that people don't understand is when the legislature passes laws, they always create an effective date. And most things are effective November 1st of the year. So whatever was done in the last legislative session that ended in May, those laws usually go into effect, November 1st later that year. They can make things go into effect immediately. They did that with the tracking device rule. And it's my understanding that the OBNDD law that was passed goes into effect on November 1st. So that's part of the issue about when licensing applications become available and that registration that they're asking for. Brandon asks, will this lawsuit take years to pan out? And if so, won't the legislature have made permanent rules by then? Well, Braden, sorry. My hope is it doesn't take years to pan out. And yes, permanent rules should be made, but that doesn't mean that they will make appropriate personal rules permanent rules. If they don't make appropriate permanent rules, we're still going to be going through all of this. That's the problem, is they're not listening to what their authority is and what they're supposed to be doing. No, there's not monetary compensation available right now. He asked if there's criminal liability for malicious intent. Not in the rulemaking, but on some of that bad acting that's been going on behind the scenes. There might be some criminal liability for that. We're expecting Chelsea Church to have charges filed against her pretty soon. I expect that there might be some more criminal charges that come out of that. Christian asked about owning a gun with a card. We talked about that. Lindsay asked about the working groups yesterday. Did they help our case? I don't know that they helped our case. I don't know that they heard our case. I think the commissioner said some things that I intend to have transcribed and I can use to my benefit. We talked about the board. Frank asked about that. Frank says, I see that various groups that receive federal funding stating that they must honor federal law, meaning they would ignore 788. Mainly law enforcement, but most recently OU and OSU. How true is that? Are they in danger of losing funds, etc.? So, going back and kind of having our civics lessons for a minute. The federal government is a government of limited powers. They only have the powers that are reserved to them in the Constitution, and all other powers go to the states. So we hear a lot this idea of states' rights. Well, that's a misnomer in terms, first of all. Government has powers, people have rights. So the federal government is a government of limited powers, and they have the powers that are reserved to them in the Constitution, and all other powers go to the states. And then the states have those powers, and the 10th Amendment is that amendment that talks about that which isn't reserved to the federal government goes to the states. And that's why there is this states amendment about the 10th Amendment that has been proposed at a federal level to address certain issues that are regulated at the state level that conflict with the federal level, marijuana being one of those, and to sort of re-energize the power that exists under the 10th Amendment. And one of the things that it's important to think about, know about, and understand is that the federal government does most of its regulation under its ability to regulate interstate commerce. And so interstate commerce under the federal scheme really went pretty far for a long time until they got into this Guns Free School Zones Act and the Women's Anti-Violence Act. And the Supreme Court finally said, hey guys, you're going too far. But basically, let's use my box of Kleenex here. This box is made one place, the tissues are made one place, the ink is probably someplace else, and then after all of it's assembled, it's put on a truck and it's shipped somewhere. And so this whole box was purchased here in Oklahoma, but it probably wasn't, the box probably wasn't manufactured here, the tissue wasn't manufactured here, the truck that delivered it probably wasn't manufactured here, but it somehow ended up here in Oklahoma, and I bought it at the Crest store, and I have it now because I have allergies. So that's interstate commerce. You've got a product that's moving across the country in interstate commerce, and that's how the federal government regulates things. And so they use their commerce power to regulate things. The other things that they use is their money powers. And so we do not have a national speed limit. The speed limits are different in different states, but the feds do control speed limits on highways through the use of highway funds. And they say, if you don't do what we tell you to do, we're going to take away your funds. So if the feds decide to come in and regulate somebody that's doing something with marijuana and say, we're going to take away your funds if you don't do what we say, which is prohibit marijuana or its use, possession, whatever, in this instance, and the people basically say, bring it, the feds can come in and they can take that money away because it's their money and they're appropriating it and they have the right to do it. So yeah, there's a risk to people who receive federal money if they allow this to come on, and it just depends on what the feds want to do and how much they're going to come in and try to regulate that.
Isn't that applied to alcohol drinking and smoked and tobacco products as well? Because those can't be limited either.
Well, you've got other issues that go to that too, but yes.
Oh, I'm remembering from my government class about alcohol. But
Okay. Shh. She's questioning me over here.
I just...
Wade says they need to let us have mother plants, etc. Yeah, that just sort of magically appears. You can't, nobody's going to pass a law that says you get to move that in interstate commerce, because that's a direct violation of federal law. And that's inviting the feds to come talk to you, and nobody really wants to be talked to by the feds. So how's it going to happen? Well, it just magically appears, and everybody's going to have to be okay with that's the law. Brittany asks why the Department of Health is in charge of this. Well, the folks who wrote State Question 788 said the Department of Health gets to make those regulations on certain things. And so if they had said agriculture got to do it, it would be agriculture that's in charge of it. So If you don't like Department of Health, you got to talk to those people who wrote 788 and picked the Department of Health. That's probably not who I would have picked. But I didn't write it, and that was who was chosen, and it was placed in the Public Health Code, and since it's in the Public Health Code, that is something that is appropriate for the Department of Health to regulate. Sandy McGuire, quasi-family member. Sandy says, the citizens of the state of Oklahoma want medical marijuana. Why do those responsible for implementing this program think they have the right to stop our choice from becoming reality? Why is the Department of Health in charge of it? We just talked about that. Why do they think they have the ability to stop it? Because that's who they are and that's what they do, and we don't traditionally stop them. So if you don't want them to do it, we all need to step up and stop them and show them that they work for you and they work for me and the people that they vote for, and you have to use your grassroots power to call and write and appear. And just like the teachers stormed the Capitol in April, you have the right to demonstrate and make your voice heard about what you want, and you can do that through demonstration. You can do it through... What are you doing? My husband's being silly outside the door.
Because we're hungry.
Okay, I'm getting done. They're complaining they want to go eat. So you have the right to make your voice heard and do that. So if you don't like what your legislatures are doing in that regard, vote, call, write, say something, do something. Now's the time to be active. Joseph, well, if you're doing anything with a controlled substance, you got to worry about DHS. That's not an easy question to answer. This bicameral committee is not helping the Board of Health. The Board of Health is doing whatever they want to do. I think the purpose of the bicameral committee is to learn about the industry and develop legislation, which everybody agrees has to be passed, and whether the question is really whether they get on board with a special session now, or that comes back in and is done after the first of the year when the legislature goes back into regular session. Not so much about working with the Department of Health. Who would I pick over the Department of Health to oversee medical marijuana? Personally, I think it needs its own agency specifically designed to do this, a standalone agency. And that's who needs to take care of it. I think agriculture needs to be involved because obviously we've got growing. We do need to have doctors involved. We do need to have law enforcement involved. I think you would be surprised to know that there's actually a lot of pro-marijuana law enforcement out there. I actually do a lot of legal work for law enforcement officers, and am surprised about what their opinions are when you ask them what their individual opinion is versus the policy that they're told to enforce. So it is now 8:43. Wow, so we've been doing this for an hour and a half. So I am going to sign off here. I appreciate everybody coming in, and I will leave this video up. If you have more questions, you're free to submit them. I will answer them as quickly as I can. Again, I can't always tell you everything that's going on with the lawsuit because that's privileged and protected. But I do the best I can. And thank you, Dana. I'm working on feeling better. I got some steroids that are finally kicking in. So thanks a lot. Everybody have a great evening, and I'll talk to you soon. Bye.